What's up, everybody? We have our very first couple of motions filed by Sarah Boone, acting as her own attorney in her case. We're going to see how she does. It's the first time I'm going to be looking at them with you. I don't know what's in them. I don't know what she's asking for. We'll see if it's appropriate and reasonable or if it's something completely outlandish. Maybe we'll get an idea about some of the content that maybe she was arguing with her lawyers about. Who knows? We'll try to figure out what she's asking for and what we think the judge is going to do. Let's get into it. So a bunch of you guys sent me this, and it was kind of in two chunks. We're going to read the first chunk today. And if you're interested and want me to read the second chunk of motions, I think there's 2 or 3 here, and then 2 or 3 in another filing that we can look at in another video if you want to, but I'm never sure when it comes to this stuff, and we're just reading documents. So hit the like button and let me know in the comments if you want me to read the other motions by saying more motions. But let's get into exactly what she's asking for here. In the circuit court, and by the way, if you're wondering how she knows how to format these, she has the other motions. She's seen what the other lawyers are doing. That's where she's copying a lot of the language and format. In the circuit court, the Ninth Judicial Circuit, State versus Boone, temporary motion for reservation of proposed costs to acquire investigator for defendant's defense in trial. So we know she met that investigator. I don't know if she means more money for him or if she wants to pick her own investigator. We know she also kind of has her own investigator. Comes now, Sarah Boone, pro se, indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire investigator for defendant's defense in trial. Investigator to be determined. So we don't know which of those investigators or maybe a new one she's looking at. Total amount requesting to be determined. Not much for the judge to decide there. How to calculate. Unknown by defendant. Reason. No discovery or case materials provided to defendant from the judge. This is before the last hearing where they were figuring out how to put it on the... Actually, yeah, so she wouldn't even know about that investigator she met because she wrote these before she met that investigator. But hey, maybe the court was answering her prayers before she even asked, right? But she's getting her discovery now. At the time, she didn't have it. This temporary motion is being submitted to meet the delegated due date of 7/22/24 by the judge and court as stated to the defendant in the order dated 6/28/24. The defendant is trying to avoid any further persecution from the judge and court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. I expect to see a lot of that throughout her own defense. The exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion. Once the defendant has finally received, she will be able to proceed, will revise and resubmit this motion upon completion, other review and research of the content. So basically what she's saying is, once I actually have the discovery and the case material, then I'll put in who the investigator is, how much money I need, once I figure out how to calculate it and what I need to do. But she needs the judge's help. Nothing totally unreasonable, but she's basically just trying to stay within the time period, which I got to be honest with you, is showing a certain level of competence to her being able to represent herself. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests this honorable court to receive any and all costs proposed to be incurred to acquire investigator for and in the defense of her criminal case for trial. The defendant's requests are in good faith and her merits are worthy, insisting to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and representation of the court. In conclusion, this temporary motion for reservation of proposed costs to acquire investigator for defendant's defense in trial should be granted. So basically, she's asking for money to hire an investigator to help her in her defense. Seems simple enough. Then her oath, her certificate of service. All right, next one. Temporary motion for a reservation of proposed costs to acquire expert witness for defendant's defense in trial. We know that her lawyers had asked for something similar as well. Comes now Boone and requests this expert witness to be determined, total amount requesting to be determined, how to calculate, unknown, Defendant's reason, no discovery for case materials provided by judge. Temporary motion submitted, okay, basically the same thing. Trying to avoid further delay. Exceeded the time limit. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests honorable court to reserve any and all costs. Her conclusion, she wants money for an expert. Again, not unreasonable if she can explain what the expert is, that she has an expert, and that it's not going to cause a delay in trial. Certificate of service. All right, next motion. Temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense in trial. Expect this court to reserve proposed costs for the witnesses. Defendant is trying to avoid further persecution. Exceeded time limit at waiting to receive the defendant's discovery. Okay, so same arguments that she's making here, indigent defendant. But this one is just she wants costs to acquire all witnesses she may need for her defense. So either going out searching for them, maybe paying for their transportation. I don't know what she's going to ask for there specifically. And then her certificate of service is kind of funny. She does a certificate of service every single time. All right, next is the temporary motion for depositions to be conducted. Per Florida Rule of Criminal Procedure 3.220 by defendant, unrepresented attorney, and position ordered by the judge and court. Comes there, Sarah Boone asking for that. She doesn't know how much it's going to cost or how to calculate it. And the reason is she's been forced to be pro se. The judge forced her to be pro se and no discovery has been provided to her. Again, all this is before she met with the court and he explained how he's going to give her the discovery. States generally at any time after the filing of the charging document, any party may take the deposition upon oral examination of any person authorized by this rule. In any case, no person shall be deposed more than once except by consent of the parties or by order of the court issued on good cause therein. A witness who refused to obey a duly served subpoena may be adjudged in contempt of the court from which the subpoena was issued. The deponent may, without leave of court, take the deposition of any witness listed by the prosecutor as a Category A witness after receipt by the defendant of the discovery exhibit. The defendant may, without leave of court, take the deposition of any unlisted witness who may have information relevant to the offense charged. Discovery and sanctions. She's just citing parts of the rule. If any, at any time during the course of the proceeding, it is brought to the attention of the court that a party has failed to comply with an applicable discovery rule or with an order issued pursuant to an applicable discovery rule, the court may order the party to comply with the discovery or inspection of the materials not previously disclosed or produced. Grant a continuance, grant a mistrial, prohibit the party from calling a witness not disclosed or introducing in evidence the material not disclosed, or other such, or as is deemed just under the circumstances. Willful violation by counsel or a party not represented by counsel of an applicable discovery rule or order issued pursuant thereto shall be subject to counsel or the unrepresented party to appropriate sanctions by the court. The sanctions may include, but are not limited to, contempt, I think, proceedings against the attorney or unrepresented party, as well as something of the court assessment of costs incurred by the opposing party when appropriate. Sorry, it's hard to read some of this handwriting. This temporary motion is being served to meet the deadline, trying to avoid further persecution and penalization. Wherefore, she believes she needs to be able to depose these witnesses. Here's the conclusion, the oath, and the certificate of service, and the mail that it's mailed in. Okay, actually, let's jump to a couple other ones because there's more. And by the way, so basically what she's doing here is she is just asking the court for basically anything she can get. She wants to depose witnesses. She wants to be able to call any witnesses that she needs. She wants to be able to have enough money to do so. She doesn't know how to ask for it. She doesn't know how much to ask for. None of that is, I see, incredibly unreasonable. Now, what she's asking for, the witnesses that she wants, and the way she wants to depose them is going to have to be reasonable. She can't redepose everybody that has already been deposed in this case, if they've been deposed, right? Because I think some people have been deposed, but not everybody has. And she's going to have to tell the court how she's going to do it. And the biggest problem here is if she has a legitimate complaint and she doesn't have enough time to do it, is the court going to continue the case? That's the big question I would have. What is going to create a continuance? Because it's reasonable for her to get an expert. It's reasonable for her to depose witnesses. It's reasonable for her to have an investigator. But she can't reinvent the wheel. This case has already been around for years. So the judge is going to have to balance allowing her to prepare her defense without letting her create delays and waste more of the state's money. This one looks to be at least a little better font that I can read. All right, here we go. Motion requesting immediate relief for the defendant, asking for standby counsel, effective standby counsel, to aid and support in the preparation of the criminal case for trial. Comes now Sarah Boone, and that's what she's requesting. Defendant's justifiable reasons for requested relief and assistance are as follows. The defendant's sixth constitutional right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant under false pretenses, speculation, libel, and misconstruction. So she's basically accusing the judge of that because nobody else has taken her right away except for the judge. I think it's appropriate to have standby counsel, but again, explaining these rules to Sarah Boone and having her not complain about standby counsel is a whole other beast. By the defendant's lawful practice of her entitled first constitutional right of free speech and her God-given right to do so by writing her experience-derived truth and providing red flag exposure in her correspondence to the court, requesting needed intervention to avoid present circumstances, she has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence, progressively advance fairly and unrestricted while having reliability to be leveled equally with prosecution. Brr. That's a lot of words to basically say she doesn't think it's unfair or she doesn't think it's fair, and she doesn't think there's a level playing field here between her and the prosecution. The defendant is not an officer of this court or any court or legal system as a whole. She is not bound lawfully under oath or certified in any professional means to be or act as a legal agent or representative lacking requisite professional competency, expertise in the field of law presently and historically. So right now, she's basically saying that at this point, she doesn't think it's fair. She doesn't think she can represent herself. And the judge is forcing her into this position. Give me 1 second. The defendant is defective and ineffective counsel to self as a result, which therefore will detrimentally impact and impede favorable justice to the defendant and the opportunity of a fair trial based on equality with an unprejudiced conclusion of her case. So the judge isn't going to disagree with any of this. She's not competent. She's not a great lawyer. This is not how it's supposed to be, but she has forfeited her right. And she's obviously trying to sound a certain way using this language and these words. The defendant is presently incarcerated, which is causing and will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities in and to her ability to complete tasks and timely responsibilities suitable to the vital defense of the defendant's life and livelihood futuristically. By the court rejecting professional, educated, experience, and assistance of effective standby counsel to and for the defendant in preparation of production of her rightful defenses, results may be adverse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position to court of pro se attorney and representation of self. Examples of said unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities include, here we go. Why is this unfair? We already kind of all know, but let's see what she says. The defendant has not received from the court to date this motion any of her promised discovery. Okay, we already know what's going on with that. With only 4 days to submit my demands and motions delegated by the court will extend all those deadlines. I have no doubt about that. The defendant has not reviewed from the court to date of this motion any of the promised discovery. Okay, we know that. Only 4 days. The defendant does not have access to a computer. The judge fixed that. He fixed the discovery. The defendant does not have access to the internet. Maybe she'll get some access to the internet, but she doesn't need unfettered access to the internet. The defendant has extremely limited, irregular access to basic tablets supplied by OCCD, which the judge fixed with the computer. The defendant has access to payphones for collect calls only, limited to 15 minutes each call. The defendant does not have access to organizational supplies or production equipment, copier, printer, etc. I think she can get access to some of that. And she can use her phone calls to set up in-person meetings. And she should get actually additional access to phone calls since she's going to be defending herself. Defendant does not have access to a meeting place for privacy and case review or preparation. They can give her that. Again, it's not going to be unfettered because she is a criminal defendant accused of a violent crime. So, if she's going to want to talk to a witness, there's going to have to be law enforcement around, but that stuff's not going to get out. It's going to be confidential. There are ways to set that up. Additional daily obstructions and undetermined hardships, disadvantages, difficulties will likely come about due to being incarcerated. And once my case materials are finally received, continued application and reasoning and further lawful support of defendant requests for immediate relief with standby counsel to aid and assist in preparation of her criminal case. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. She's quoting some rules here of the state and distinct, wherein the crime shall have been committed, which district shall have been previously ascertained by law, and be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel in his defense. Right to counsel is assured by the Sixth Amendment, which has been incorporated into the Due Process Clause of the 14th Amendment. Waiver of counsel is a criminal defendant's refusal of counsel at any stage in the criminal process. I have never refused. It is made by a person with full capacity, unprepared, that is knowing, involuntary, forced, and that clearly and unequivocally rejects the representation. She's basically saying, I didn't do that. We know that. No surprise. Again, she's proving her competence by her ability to read the rules, quote the rules, write the rules, make arguments. She's going to win some, she's going to lose some, just like any lawyer. Is she as competent as a lawyer? No way. But the judge is saying, you have effectively waived your right by your actions. A defendant's decision to waive the right to counsel must not only be competent, but also knowing and voluntary. The right to waive counsel forced by the court is the right to knowingly proceed in ignorance. The court must first make inquiry. Okay, so she's going into waiver of counsel, and the judge has kind of bypassed all of this and saying, we've given you a million lawyers. You keep intentionally delaying and messing this up. So we're finding that you've effectively waived your right to counsel. Ineffective counsel, she writes that standard out. Basic rights, freedom of speech in the press. It's a little lesson in constitutional law. Right to assemble, right to due process, rights of the accused. And a lot of this is repetition. Speedy and public trial, access to the courts, 14th Amendment to the Constitution. Yeah, we're not going to read all this. It is the great and inexcusable delay in enforcement of our criminal justice system. So she's just basically rewriting different articles in the Constitution. Sheesh. She cites all the cases that these articles are citing. Basically, this is her arguing it's unfair that she doesn't have assistance of counsel. Appointment of counsel, Appointment procedure, notes of the advisory committee. Wow. All right, so here's her final page kind of argument. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the honorable court to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. The defendant is requesting collaboration. Again, basically the same things. I don't think the judge is going to like this because she's just going to want to use standby counsel as appointed counsel, and it's not the same thing. So maybe he'll explain it to her and appoint standby counsel. I probably would at least try to do that. But once she complains about standby counsel, I'll say, this is it, Ms. Boone. Do you want standby counsel or do you not? She wants to be collaboration, correct understanding, and overall perspective of, and in her extraordinary circumstances, by rendering her cognitive incapacities, procedural inabilities, and extremely limited capabilities altogether as fact, and concluding a remedy of assistance is rightfully needed to be provided to the defendant by the court. I think that would be the best of both worlds if they could get her standby counsel, but I'm also realistic in how she would probably treat standby counsel. Appointment of vital standby counsel will lessen greatly her probabilities of further loss, damage, spoliation, and oppression in her criminal case. Fair and equal position by fair and equal opportunity also will be greatly enhanced. The defendant's requests are in good faith and her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney. Conclusion, motion for immediate relief defendant by appointing effective standby counsel to aid in support and preparation of her case for trial should be granted. Certificate of service, and there's the end of the letter. So basically, all these motions, what she's asking for is money to hire an investigator, expert witness, and to get all of her witnesses that she needs, money for depositions, the ability to depose witnesses, some way for her to use a computer, internet, a space to talk to witnesses, a space to work, more phone calls, and then, of course, most importantly, effective standby counsel. I think the court will grant a number of these things. He's already granted some of them. I think he's going to provide her with as many resources as he possibly can to allow her to be as successful as she possibly can in representing herself. It's not going to be perfect, but it should be something. She shouldn't have her hands completely tied behind her back. So he's definitely not going to grant everything, and I would be interested to see how standby counsel goes. And I think anything he grants, he's going to make sure to make very clear this is not going to delay the trial. So we ended up getting through all of them quickly. I didn't realize she just basically rewrote the Constitution and some of the rules. So we got it all in a relatively short video. So hit the like button for that. Make sure you guys subscribe to our page. And until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.